Yes, Mr. Cunningham.
My lady, my lords, I am concerned that there's a lot to get through on my side, so I will be going at some speed. Please slow me down as necessary, but we do feel that there is ground that needs to be covered, particularly given that the primary ground of appeal invites you to do the exercise again, but you haven't really been shown much of the prejudicial side on my client's part. So I do need to show you a bit of that, so that you really understand the position that the learned deputy judge was in.
Well, as you know, we have read your skeleton argument with care.
Thank you. Great.
And I think we've all dipped into the authorities to which you refer.
That's very helpful, my lady. Thank you. Can I just set out our position in a nutshell?
Certainly.
There are two parts to this, to Panasonic's appeal. The first part is that it is in effect a request to this court to overlook the new ethos that was introduced in April 2013 on the basis that this is an exceptional case. But those rules, the new rules, apply to all cases. And the second part is that this is not in any event an exceptional case. Now, as to the first part, it's common ground that the post-Jackson report changes to the CPR, as reviewed by this court in Mitchell and in Denton, were intended to execute a change in procedural ethos. And we'll come to consider briefly the detail of those changes, but the stated intention was to bring to an end the culture of toleration of delay and non-compliance with court orders. This appeal is concerned with an ignominious catalogue of rule flouting and order breaching, possibly unprecedented, certainly under these new rules. And the judge reviewed Panasonic's behaviour in stinging terms, and there's no challenge to his findings in that regard. Instead, my learned friend's presentation is all about the extensive prejudice asserted by Panasonic. He complains that the sanction imposed was disproportionate and lacking in balance. But that, we say, is an argument a decade out of time. The new ethos is one which prioritises compliance, but you can only prioritise compliance by relegating the importance of treating the defaulting party with perfect fairness. And that is acknowledged, that tension is acknowledged in the speech that Lord Dyson gave to the convocation of district judges, and in the Mitchell case itself, where this court explained that it was wrong to focus exclusively on doing justice between the parties in the individual case. That is really at the heart of my learned friend's appeal. As to whether this is really exceptional, this case, the argument boils down to, never mind Panasonic's misbehaviour, look at the £30 million. Mitchell and Denton are all very well, my learned friend says, but they don't apply to such big numbers. And now, of course, the first point is that that figure is itself liable to mislead, because this is all contingent. The outcome of the deputy judge's decision is that there is a chance of significant detriment to Panasonic. It may make very little difference, or indeed none at all, because to be clear, Panasonic's primary position is that their infringing activities yielded zero profit. If they're right about that, this makes no difference at all. But even this number doesn't take us out of the normal run of sanctions cases, because it's only a proportion of their defence in any event. Significant proportion, to be sure, but it's not uncommon for the refusal of sanctions to result in the failure of an entire claim or an entire defence. And that's not this case. I mean, there are two examples in the authorities. You've got Syed and Shah, where Mr. Justice Trower had an appeal from the county court about witness statements that were a month late, no history of non-compliance or other aggravating factors. The trial could go ahead as listed, but relief from sanctions was denied at first instance and on appeal, even though the effect was the end of the claim. Because that's what the new rules lead you to. That's the new ethos. And there's going to be some rough justice, because justice is a bigger concept and looks outside the individual case. A similar outcome in the Clearway case. Witness statements 2 months late, less than a month before trial, but it was accepted the trial could go ahead. the inefficiency, the procedural inefficiency was found in the fact that the PTR had to be adjourned twice. The outcome was no permission for witness statements, Master of the Rolls dismissed the appeal, and the claim failed. And even if you're looking for big numbers, there's Sinclair and Dorsey, which isn't in the bundles, claim for an excess of £30 million, failure to pay security for costs in time, application for relief from sanction was dismissed, and the claim failed. So these sorts of outcomes are not unusual under the new ethos. Let me then take you to where we find some useful guidance on that new ethos. Perhaps you could start in my skeleton argument, in the core bundle tab 5. Hopefully on page 51 you have a colour version of the skeleton which has some red text which shows you what has changed and what changed in April 2013. We're concerned with the overriding objective of Rule 1.1 and with CPR 3.9. But what changed in the overriding objective, 2 references to proportionate cost, and then subparagraph F, the need to enforce compliance with rules, practice, directions, and orders. That becomes a factor, or became a factor, in dealing with cases justly. And as I've already pointed out, there's an inherent conflict between that compliance and seeking a perfectly fair outcome between the parties. And you'll see that there is a striking correspondence between the changes made in April 2013 to the overriding objective and those made to CPR 3.9. So the 2 prioritised factors in 3.9 are for litigation to be conducted efficiently and proportionate cost, and to enforce compliance with rules, practice, directions, and orders. Those are both elements of the overriding objective. And that is why, on our side, we take issue with my learned friend's suggestion that this application is critically dependent on it being characterised as a relief from sanctions case. We don't agree. They say, somewhat baldly in their paragraph 53, there can be little doubt that the judge would have permitted Panasonic's application if he hadn't considered it was a relief from sanctions case. Again, we don't agree. We suggest that as soon as the compliance ethos is brought to bear, Panasonic is in grievous difficulty.
If you're suggesting that the 2 come to the same, how do you fit amendments to pleadings into that? I mean, the court makes an order, defence by 31st of October, either no defence is put in, or alternatively later on somebody wants to amend the defence. You don't go through the relief from sanctions exercise.
Absolutely right, and that's because there aren't grave difficulties in allowing an amendment to a pleading. It's a quotidian thing. The procedure can easily accommodate it unless it's very late before trial, in which case it won't be allowed for precisely that reason.
But that's an example where you don't just say, look, this is the litigation not being conducted efficiently, and it's important to enforce the rules. You look at things differently.
My lord, absolutely right. It's, paragraph F doesn't stand alone. It's just part of the change. But what we'll see is that, from the speech of Lord Dyson, is that these changes were brought in at the same time to affect the same change in ethos. So it shouldn't make a massive difference. Let's say that the question's quite finely balanced. Is it a sanctions case or not? You've still got hugely disruptive breaches, a series of appalling behaviour. And it's
so what you're saying to us is, if this was not a sanctions case, then nevertheless, given everything you've told us about the change in ethos and so on and so forth, in the exercise of the judge's discretion, against that backdrop, the result would have been the same.
I do say that. And indeed, you'll see that this is also was also the view of the Supreme Court in the AIC case, because they were faced with a question: is this relief from sanctions or not? The Supreme Court says it doesn't matter, because look at subparagraph F to the overriding objective. You get to the same place either way. Now, I don't say that's going to be the position in every case, but when you've had seriously disruptive breaches, and I'll explain why that's what these were, it's unlikely to matter a great deal. And can I perhaps show you where you see that in the speech of Lord Dyson, which is towards the back of the authorities bundle. It's important to consider the audience for this speech. This is Lord Dyson, Master of the Rolls at that stage, telling district judges how they should be changing their approach in light of these the changes to the CPR. So if we could start, please, towards the end of paragraph 7, he picks up the.
So just so I'm clear in my mind, I'm just getting the chronology right.
Yes.
So this speech was made
March 2013.
So after Mitchell, but before Denton.
No, before.
Before
either.
both.
So what's happened is that the changes are made to the CPR and to 3.9 in April 2013. The month before, Lord Dyson gives this speech, and then he sits on Mitchell, which is, I think, the following year.
Right, thank you.
So you'll see the changes highlighted under paragraph 7. And then if I can move you forward towards the end of paragraph 11, this is just the overriding objective here. It says the framework is intended to ensure that all litigants have fair access to the courts and a fair opportunity to proceed to judgment. As to what that means, if you go to paragraph 12, he says there are going to be 2 objectives. The first is to ensure that parties do not spend more than proportionate costs in conducting their own litigation. The second is that they don't expend more of the court's time and resources than is proportionate, given the need to ensure that all other users can have fair access. And then he deals with the consequences. Paragraph 13, parties may be denied the opportunity to adduce evidence. And he said at 14 that this may seem harsh and may appear to amount to a denial of justice. The court's refusal to grant relief from a sanction, for instance, may appear to be a denial of the need to ensure that justice is done as between the parties. That is Panasonic's plea before this court. But it's not a denial of justice, as he explains in paragraph 15. He says, dealing with a case justly does not simply mean ensuring that a decision is reached on the merits. It's a mistake to assume that it does. Because you have to look at the position more widely, and in particular, to consider other court users. So at 16, he says it's not enough to consider the need to secure justice between the parties. And then at the end of paragraph 18 over the page, conclusion, the new emphasis in the overriding objective on proportionate cost and compliance is intended to make sure the wider public interest remains at the forefront of all our minds. Not something that really was trespassed upon in my own friend's appeal. Now that's just the overriding objective. He then moves on to CPR 3.9, and he gives 3 reasons for the changed drafting. The first 2, in paragraphs 20 and 21, simplification and control of costs. In relation to that latter, he identifies one problem as being too great a desire to err on the side of individual justice at the expense of wider procedural efficiency. And then the third, which is paragraph 23, is expressly linked back to the overriding objective. He says this, by emphasising the need to take account of the new explicit elements of the overriding objective, Rule 3.9 is intended to eliminate lax application and any culture of toleration. Now, my lady, my lords, that's why we say that the overriding objective and CPR 3.9 march in lockstep. Because, in fact, he's relying on the overriding objective to explain the policy for 3.9. And then he addresses the argument that the new harsh approach is inimical to justice. And if I could pick it up at the bottom of paragraph 24 over the page, so page 337 of the bundle, he says that the justice system has to command public confidence through securing for the majority, many of whom have limited resources, access to a system that itself must operate with limited resources. doing justice in the individual case can only be achieved through a fair procedure operating in a way that is fair to all. And then he makes the critical point that I mentioned at the outset about the conflict between individual justice and compliance. Paragraph 25, he says, in order to achieve this, the Wolf reforms and now the Jackson reforms were and are not intended to render the overriding objective or Rule 3.9 subject to an overarching consideration of securing justice in the individual case. If that had been the intention, a tough application to compliance would have been difficult to justify and even more problematic in practice. That's really important. It's problematic in practice because if you promote compliance, then something has to give. And what he's saying is what gives is securing justice in the individual case. And paragraph 26, the relationship between justice and procedure has changed. And the last line, justice in the individual case is now only achievable through the proper application of the CPR consistently with the overriding objective. And that is where Mitchell and Denton come from. It's a change in the ethos.
By way of sort of caveat to that, this is Lord Dyson. I think Lord Dyson was in the Matthews case, wasn't he? Where they said that no doctrine of implied sanction.
That's correct, and I will be coming on to sanctions and implied sanctions in due course. But there's no doubt that CPR 3.9 is not intended to be some sort of erratic branch of our rules. It is intended to be consistent with the overriding objective and vice versa. And that, of course, is why paragraph F comes in to the overriding objective. Now, this is all effectively endorsed in Mitchell, and indeed Lord Dyson refers to this speech in paragraph in Mitchell. Now, there's one important point that also emerges from Mitchell that my learned friend took you to, which is that paragraph 45, I don't think we need to turn it up, says that if a sanction is set out in a rule or an order, the sanctioned party cannot argue that it does not comply with the overriding objective. That's a sort of a starting assumption. And I just want to show you how that was relied on in Chartwell, because we can sort of kill two birds with one stone there. And Chartwell is behind tab 3 of the authorities bundle. Chartwell was a case about late witness statements. And if you could turn please to paragraph 22 on page 31, you'll see that Lord Justice Davis sets out the terms of CPR 3210. If a witness statement for use at trial is not served by the time specified by the court, then the witness may not be called to give oral evidence unless the court gives permission. Now that very closely mirrors the language of CPR 3121, to which we will return. My learned friend asserted to you that this was an instance of an implied sanction. Well, it's nothing of the sort, as Lord Justice Davis explains in this case. Perhaps my lady, my lords, could read paragraphs 24 through to 27. So absolutely clear that that is considered an express sanction provided by the rules, and it engages the doctrine of relief from sanctions. And at 24, mirroring what is said in Mitchell. Lord Justice Davis says, the question is thus not whether the sanction prescribed by the rule is itself disproportionate or unjust, but whether the sanction should be disapplied in a particular case. Now, if one thinks of the Denton tests, that makes perfect sense. The starting point is that the sanction set out in the rules is proportionate, compliant with the overriding objective, and that is why the Denton tests concentrate on the behaviour of the defaulting party. Do you deserve relief? Question 1, how bad was your breach? Question 2, why did you do it? Because the starting point is that the sanction is justified, and the question is, should it be disapplied? And that's all of a piece with this new ethos. But the proportionality question plays a very minor role in that, as we'll come to see. For my lady, my lord's notes, the same approach to CPR 3210 is taken in Denton itself, where 3210 is described as involving an automatic sanction that applies once the specified date for exchange of witness statements is missed. So again, directly contrary to my learned friend's submission that these are implied sanction provisions. Now, the reason I ask you to read on to paragraph 27 is because of the question about when does this sanction bite? And the answer is as soon as the deadline has passed. We can move on then to the detail of part 31, and in particular we're going to be looking at rules 3111 and 3121. For these purposes, could you perhaps take our skeleton, which is in the core bundle, tab 5, page 56. Now, what we sought to do under paragraph 25 was set out the overall scheme of part 31 so far as relevant. And I don't understand that summary to be in any way controversial. Now, today we're concerned with what happens under this scheme where documents are discovered after the ordered deadline for disclosure. I'll come on to the question of whether it's disclosure or not at all. But my primary case is this is in substance a disclosure order, and what has happened is that documents have just been discovered after the deadline. So paragraph 10 of the trial order, which we're concerned with, operates as an order for disclosure in relation to revenue and costs over the specified period, but it is recognised that that obligation can be more cost-effectively met with a witness statement. So rather than, and it's probably better from everyone's point of view, rather than being given reams and reams of numbers, of spreadsheets which set out these figures, it's more convenient for them to be provided in a more narrative form from someone who knows about them. They're more easily digestible. But the underlying obligation is still one of disclosure. It's turn your pockets out time so that the rights holder can inspect the extent of the profitability.
But it's not within part 31, is it?
It is within. It is within part 31 because it is the underlying obligation is a disclosure obligation.
I thought part 31 said it's applied where you'll be dealing with disclosure of documents.
Well, right. So my primary position is that if you drill down to the obligation that is found in paragraph 10, the island and tring disclosure, the island and tring obligation, it's a disclosure obligation, but it's an obligation which the disclosing party has been allowed to comply with in a slightly different way.
Well, part 31.1 says this part sets out rules about disclosure and inspection of documents.
Indeed.
Paragraph 10 of the order doesn't require you to disclose any document.
No, you do need to see how the island and tring regime has developed. So you can see it from the original decision of Mr. Justice Lightman that the infringing party needs to provide their profit information, and that is, in substance, a disclosure obligation. They have to give over...
You're required to disclose something, but you're not required to disclose any documents, are you? And paragraph 10 did not require you to disclose any documents at all.
So you and I are agreed in relation to that there was not a requirement to disclose documents. But I do say that was a disclosure obligation in substance, or if you're against me on that, it's equivalent to a disclosure obligation. It is akin to one. I don't actually think there's that much between us in relation to this. Let me show you what my learned friends say in their skeleton argument.
Sorry, just before we move on to that, you say it's akin to, but if it's not disclosure of documents, 31 doesn't apply.
Well, if it's not, yes, there's a degree of circularity there.
So you can say it's disclosure, but it's not disclosure of documents.
Oh, right. So,
and therefore 31 doesn't apply.
I think disclosure is only dealt with in Part 31. There isn't... Disclosure means disclosure of documents. According to Part 31, it means listing the documents that you then have to make available
disclosure of information
for inspection. But what's actually happening is that you have to hand over your information. You have to make available the information that is recorded in those documents. Now, things have moved on. It's not just all documentary disclosure now. And in this particular instance, that information is made available through a different mechanism. But what's actually happening here is still, in substance, a disclosure operation. It's just that there's a more convenient, cost-effective mechanism for delivery of that information. But look, absolutely, you are entirely correct that the question is, you look at paragraph 10 and you say, is this an obligation that brings with it the duties in Part 31? That's really the question. And I want to show you what my learned friends say about it in their skeleton, because I think that helps with the answer. So could we start, please, with paragraph 11. Paragraph 11, it should be noted at the outset that it was common ground, recorded by the judge, 41, that Panasonic were duty-bound to provide corrective information of the kind in Mr. Takahashi's statement, because the Island Records order was a statement in lieu of a disclosure obligation. So there are two things going on there. There's the concession that it was in lieu of a disclosure obligation, but there's also the concession that they were duty-bound. Well, the only place you can find this duty is in Part 31. Similarly, paragraph 13, third sentence. The service of Mr. Takahashi's evidence was in any event necessary to comply with the continuing obligations of disclosure. Again, there's only one candidate for the source of those continuing obligations of disclosure, and it's Part 31. And finally, paragraph 36. The inclusion of these costs in Mr. Takahashi's statement demonstrated that the trial order was not complied with, in the sense that it had required the disclosure of all costs. Well, indeed. And they characterise, my learned friends characterise the omission as akin to the late disclosure of documents. What he really wants to do is pick and choose. I don't mind this bit of Part 31 applying, the duty of ongoing disclosure, but I'm not taking with it 3121, the downside of that. But there's no warrant for that approach. You need to pull back and see the wood for the trees. There's an obligation to provide information. Part 31 polices the obligation to supply to your counterparty information in your possession. It talks about documents. That's how it used to always be done. We're a little bit more flexible now. But there has to be transparency. And this is how the court polices the transparency, with ongoing duties of disclosure and with a sanction for non-compliance.
So to be clear, you say the sanction is that if you want to depart in any respect from what you've said in your Island Records witness statement, you have to apply the relief from sanctions doctrine.
So, if there's a bit more in, can I just finish showing you how the Part 31 operates? Because it operates with this very specific asymmetry, which has not always been appreciated in the judgments.
And
What happens?
I suspect what you're going to say then is, it's not quite what I said, it's that if the person providing the statement wishes to rely on any change at all to the information provided in the statement, he has to comply with the Island Records.
Right.
He has to comply with the relief from sanctions criteria.
My Lord has the point. The key which is often overlooked, one reconciles the twin obligations in 3111 and 3121. 3111 says, if you discover a new batch of documents, you've got to disclose them. If they're relevant, you've got to list them straight away. 3121 then constrains how those documents can be used going forward. The receiving party, if they like the documents, they think, thank you very much, I'm going to use those at trial. But if they're for the benefit of the disclosing party who is in breach of the order, then permission is going to be needed.
So this context,
So
if the party puts in an Island Records statement saying this is my estimate, if when he works out the detail and does the disclosure and pleads out the case and puts in the witness statements, he finds that he has overstated a cost, you say thank you very much.
yes.
But if on the other hand he finds that he's understated the cost, he has to get relief from sanction.
He gets relief, permission of the court, and that means relief from sanction. And to be clear, if that mistake is spotted before the election, relief from sanctions should be straightforward. If it's spotted before lots of work's been done or there's been disruption, then it is going to be a relatively straightforward matter to gain relief. But that's really not what happened here. This is a very extreme case on the facts.
But leaving aside the
But
fact
the
that
mechanism,
particular case,
my
you
Lord is
say
right about the
as
mechanism.
soon as you want to increase the cost from your estimate and the statement, you have to comply with relief from sanctions criteria.
Let me just be clear. So the way the rules operate with respect to documents, let's say this was done by documents, right? So instead of at the relief hearing, my learned friends say we want to do documents, not a statement. We've got a schedule because we've got a really nice accountancy system which just delivers our costs, and it's very easy to agree. So we'll do documentary disclosure. That's fine. They do the disclosure. Everyone agrees Part 31 applies to it. And it turns out they missed some because there was a second accountancy system which did sales credits. And they hadn't thought to interrogate that. So the documents on the sales credit system were missed. And they then provide those subsequently. They have to, there's an obligation to disclose them when they find them. And the question is, can they rely on them? And let's say they did this. This gives the answer to my learned friend's question. Of course, you can't proceed on the basis that an artificial basis, as if you've got one hand behind your back and the witnesses will all get into terrible trouble. Imagine that second system was discovered on the first day of trial. And they turn up with a sheaf of additional paper saying, I'm sorry, there's 30 million additional costs that we need to deduct. It's going to be a straightforward decision for the trial judge. Why haven't you done it? We didn't look properly. We asked the wrong person. In fact, we found out 6 months ago, but we're only asking to bring them in now. There's no chance that material comes in. Now, that's a slightly more exaggerated example, but not much more. That is how sanctions work. Parts of your case get blotted out. It's a bit like applying to amend. I'd like to apply to amend to introduce these new, to plead these additional deductions. But I'm too late. It's the first day of trial.
You don't apply relief from sanctions.
No, you don't with an amendment. That's right. Because you haven't been required to do something by a deadline for another purpose, for another stage in the proceedings. There's a reason we have disclosure deadlines. It's so that the other parts of the proceedings that follow on behind can take effect in good order.
But that definitely applies to statements of case. You need the statements of case at the beginning for all the rest to follow.
But we know from experience that minor amendments and tweaks to statements of case can be accommodated without great disruption, whereas significant changes in disclosure may be more problematic. And so the rules have been drafted in a different way in relation to late disclosure and late witness statements.
And I will shut up, but just completing your point on the implied sanction. The implied sanction is not merely that you can't produce the document, so to speak, it's you can't run the case at all. You can't say, oh, I accept I can't produce the document showing such and such, but I can still say it.
Well, you're obliged to produce the document. You can't rely on it.
But you can't say it either.
It's a matter for the trial judge how that sanction then works in practice and what is meant by you can't rely on the document. But that's what the rule says. So that's 3121, and it operates in this asymmetric way by only precluding reliance by the disclosing party. The terms of the rule are open to misinterpretation because of the reference to failure to disclose and the meaning of disclosure. And this was something that my learned friend sought to extract from the McTeer case. But as my Lord Justice Newey, I think, has already spotted, that argument was dealt with in the Soka case. Failure to disclose means failure to disclose duly. And what that means, in terms, is that if you miss your disclosure deadline and you subsequently have documents that you want to rely upon, then you're going to need relief from sanctions. And one gets that from paragraph 20 of the judgment of Lord Justice Stanley Burnton in the Soka case, which is the authorities bundle 2. If you're happy for me not to go there, I don't think it's a controversial proposition, not least because it makes a nonsense of the rule if you take a different view.
I mean, the difficulty is, as we were touching on earlier, leave aside Ireland record statements.
Yeah.
You know, as trial judges, we're used to things being handed in at the last moment and not going through the relief and sanctions criteria.
Right. So it's let's look at it in that way then, because this statement was produced for a very narrow purpose. It was produced to allow for an election by my client, whereupon the action against Panasonic goes off down one of two completely inconsistent routes. Once we make the election, that statement is spent. We've looked at the numbers, we've made our choice, and we're off. So what actually happened with Takahashi is strongly analogous to post-trial disclosure. What they're saying is, you've made your election, you've relied on Varna, and we've headed off down the account route, but now we want to wind the clock back. We want to give you something you needed when you made that election. Because it's not trial evidence. Mr. Varna doesn't have to come to any trial, nor does Mr. Takahashi. So, in many ways, the Island and Tring procedure is this sort of interstitial procedure. It's not the liability trial, but it's part of the relief you get at the liability trial, and it's not the quantum stage. But what's absolutely clear is, once the election has been made, Varna's statement is no longer of any use. It's like a post, and it's like coming along after trial and say, we've got some more documents. We have to disclose them. We're obliged to, continuing duty. The trial judge isn't going to say, oh, let's go through all that again. I think we probably should look at McTeer, because I hope I can help to show what the problem was in McTeer, and it sits well with what I've told you so far about reliance and disclosure. So if you're in the Authorities tab 9, and if we go straight forward to paragraph 36. Paragraph 36, the problem here was that the documents that had been disclosed were in fact of limited, if any, relevance. None of the documents seem to have been of particular importance. They included BWL's management accounts for June and March, which ought to have been available to the claimants and administrators in any event. And then skipping forward, please, to 37, maybe assumed that the documents in question were actually sufficiently relevant to require disclosure, but even on that assumption, if they were either largely confirmative of other documents that were already disclosed or already in the possession of the claimants, it's hard to see how the judge was justified in inferring a deliberate plan to subvert the litigation process. So these were documents that were inherently equivocal. The claimants didn't even say, the defence didn't even say, we need them, we want to rely on them. So in the context of 3121, it wasn't clear that there was a sanction in any event. They just said, we found them, because counsel told us to look somewhere else. We found them, here they are. And we think for good order we apply for relief from sanctions. But it wasn't that they wanted to deploy them and say, aha, this changes everything. They just thought they were complying with their disclosure duty. And it's in that context that the Master of the Rolls says it found it quite a difficult question. But you even see, you'll see even at 48 that the relevance to the issues is a key part of his assessment. And that's simply not an issue here. The additional 30 million deduction is only in Panasonic's interests. This is absolutely a paradigm case of a party who failed with their, what I'm calling their disclosure obligations, who then wants to rely on the new materials. So the only other thing to draw your attention to is that paragraph 47 is not incorrect on its face, because it's open to interpretations, but is liable to conflict with SOCA. It's also not part of the ratio of McTeer. So that's what I say about the law, and I want to move on to take you through what we call the Panasonic charge sheet, so you've understood what the judge was looking at. You will have seen the trial order, and we're concerned with paragraph 10 of the trial order, which was the obligation to provide this information. Two things about that I invite you to note. First, it comes with a built-in procedural safeguard. The judge ordered that the information should be in a witness statement accompanied by a statement of truth, and that it should come from a Panasonic director. Second, the information itself, revenue, direct costs, and in effect indirect costs that the defence will claim should be deducted. That's their own internal information. That's why this is in substance a disclosure obligation, as I said, turning out your pockets. Now the judge dealt with this in the early parts of his judgment, so this is Core Bundle tab 9, and at paragraph 6 he quotes from Ireland and Tring itself, and in particular note the highlighted part. The plaintiff is not entitled to know exactly any amount of damages or profits, but only to such information as the court considers to be a fair basis in the circumstances of the case. In other words, it's for the court to decide on the facts of each case what information ought fairly to be provided. Then he sets out paragraph 10 of the order, and as he records at paragraph 8, this is the information which Mr. Justice Morgan considered to be a fair basis in the circumstances of this particular case for an election. Now, my learned friend relies on various island and Tring disclosure authorities to the effect that, well, it's only meant to be a rough and ready estimate. He could have deployed those authorities before Mr. Justice Morgan for the purposes of resisting the terms of paragraph 10. But he didn't. This paragraph was agreed between the parties. And so these cases can't help Panasonic now. Once the order was sealed, the only issue is how did Panasonic respond to it? Now, as to how they responded to it, the first breach was that Mr. Varner was not a director, and the judge deals with this in his paragraphs 47 and 48. But in particular 48, he describes the extraordinary manner in which Panasonic responded to this. Because one might have thought Mr. Varner's statement would at least have been authorised by or produced in conjunction with the director, given the terms of the order. None of that happened. Mr. Varner's statement was authorised by Ms. Hollow, a legal officer who was not a director, nor did Mr. Varner liaise with Mr. Takahashi or with other senior members of the Panasonic finance team. Instead, he liaised with a Mr. Shaughnessy, but Mr. Shaughnessy was not a director, nor was Mr. Shaughnessy senior enough to know the matters subsequently relied on by Mr. Takahashi. What this means is that Panasonic didn't serve any compliant evidence whatsoever. And strictly, they need the court's permission to repair that default. But so far as there is information present in the Varner statement, that permission is not and has never been resisted by Lufthansa.
But how would that work? So you say, look, this statement doesn't comply with the order at all. There is no statement complying with the order.
Yeah.
So what's the implied sanction for that?
So there are two, well, I'm coming on to the second related breach, which is the incomplete nature.
Okay, well, can we just pause there one moment?
Yes.
If we're in the territory of implied sanction, what is the implied sanction for failing to comply with the order by not putting in anything?
I don't rely on any sanction imposed exclusively for the director breach.
Do you say there was an implied sanction for failure to comply with the order by not putting in anything?
No, the director breach is part of the story, and it becomes very important when you look at Denton, the second step of Denton. But the judge did not apply a sanction for the director breach.
I follow on that, but just coming back, I think you've answered this question. As a matter of principle, you do not suggest that there was an implied sanction for failing to comply with the order at all.
For the director's breach.
Well, no, ignore the director for a moment. Suppose Panasonic simply had failed to comply with paragraph 10 of Ms. Justice Morgan's order. Was there an implied sanction for that?
Let's say they didn't serve anything by the date.
If they didn't serve anything by the date, right, yeah, so I can answer that question. And then they subsequently serve let's say they subsequently serve Varner. So Varner, nothing by the date, and then a month, maybe we get an unless order, and then Varner comes along.
Well, no, that's the point of the question. At the date, at least to my mind, part of the point that I'm interested in hearing the answer to, I hope it's the same thing as Lord Justice Newey, but I think it is. If you imagine the situation the day after the deadline,
Yes.
nothing has happened other than a failure to serve in accordance with the deadline.
Yes.
At that point, at least speaking for myself, it's not obvious to me that there is an implied sanction.
Right.
You could then go back to court and get a less order.
Yes, no, we are agreed. We are agreed.
Okay.
The sanction by 3121 applies when the later disclosure is given, right? It's engaged because that, although there's a sort of loaded sanction, but you don't know what it is, because it's only when there are new documents provided that you can see, now I know what the consequences of that breach are.
Well, I think applying your logic, you would say they can't rely on any of it.
Right.
Because it wasn't duly disclosed. Therefore, they have to apply for relief from sanction for anything.
I could have adopted that position, but I didn't, and the judge didn't make an order on that basis. The judge made an order on the basis that there was a failure to provide the information required. I'm explaining to you that that is, in substance, a Part 31 disclosure failure, and that the sanction that the judge applied was precisely coterminous with 3121.
But doesn't it follow from your case that actually they had to use 3121 for everything?
No, because they provided some information, and I could have made a case to the judge that nothing's ever been compliant, and therefore there is some other consequence. But that wasn't the position that we argued for either then or now. We accept that the director's breach is not one that has consequences in and of itself, but it's part of the story because it's the nexus between that and the informational breach. And it's the informational breach that we need to look at next. And that nexus in particular, which the judge deals with in the last 2 lines of paragraph 47, Mr. Varner was not senior enough to be familiar with the matters relied on by Takahashi. That was the very reason why Mr. Varner's statement turned out to be inaccurate. And then 49, the reason Mr. Varner's statement failed to include the matters subsequently relied on by Mr. Takahashi is because Panasonic gave the job of complying with paragraph 10 to a junior member of staff, and that junior member of staff did it without any involvement with or authorization from a director with knowledge of the relevant facts. So an important question for the judge and for this court, how was it that Mr. Varner came to be given this task? And the answer to that is in Mr. Bennett's 6th statement, which is the supplemental bundle, tab 17, page 117 of the bundle. Could you please read to yourselves paragraphs 69 to 71? No one from Panasonic has given evidence on this point. We don't know how they saw this order, so we've just got this to go on. But it's somewhat surprising evidence. If you look at the middle of paragraph 71, Mr. Bennett says, although I did not understand him to be a statutory director, I understood that he held a role of some responsibility within Panasonic. It was an error on my part not to ask someone who was a director. And that appears to be admitting willful non-compliance with the trial order. Mr. Bennett knew that Mr. Varner was not a director, but he thought he would do nonetheless. My lady, my lords, the director requirement was a procedural safeguard imposed for Lufthansa's benefit. It was there to ensure that Lufthansa received accurate information. It was not in Panasonic's gift to waive that obligation put in Mr. Justice Morgan's order. Now we come to the thorny question of the extent of the non-compliance, something that Panasonic relies heavily for the purpose of this appeal. They say, we gave this task to someone who didn't know about £30 million worth of deductions. Well, that point cuts both ways. And in particular, it conclusively establishes the significance of these breaches. It conclusively establishes, we submit, that the Varna statement did not provide a reliable basis upon which Lufthansa could elect between profits and damages. It overstated those profits by a significant, probably confidential proportion. It is, on any view, a hugely significant error. Now, if that omission, or those omissions, could have resulted in a reasonable party in Lufthansa's position electing for damages instead of profits, it must follow that the Varna statement was not fit for purpose. That was all it was there for. And that, we say, is the proposition at the heart of Panasonic's appeal, that their breach was so significant that the statement that they served was not fit for the purpose for which it was ordered. And the reason why is because they breached the order by not getting a director. On this point, we do not accept my learned friend's response to my Lord Justice Birss about the relative value of an account and an inquiry on the new figures. It is true that Lufthansa is a licensor, but that tells you nothing about the level of royalties that Lufthansa received. But equally importantly, accounts of profits are notoriously capricious and risky remedies. And if you get an island and treeing statement which takes away a high proportion of the profits asserted, it is very possible that a different election would be made. In particular, a risk-averse litigant would be quite likely to choose a different route. So that takes us to November 2020. But then there was a further breach of the disclosure obligations in January 2021. Panasonic accept they were under disclosure obligations, and those obligations, as voiced by 31.11.2, are to immediately notify any party when new documents come to your attention. And as the judge held, that raised the question, well, when did they come to your attention, Panasonic? And he made findings in respect of that date in paragraphs 50, 53 and 55 of his judgment. He said it was in January 2021. And he helpfully explained what they ought to have done. He said, what should have, this is paragraph 89, what should have happened in January 2021 is that Panasonic should have told both Lufthansa and the court that they had reason to believe Mr. Varna's statement was inaccurate to a significant extent, but they had not yet had the time to identify the precise figures which should have been given. There was a delay of 23 months before Panasonic gave that notification. There's another important feature of what happened in January 2021. It wasn't just that Panasonic discovered this problem, they also discovered why they had the problem. It was that they'd given the job to someone who was too junior. If you still have before you Mr. Bennett's sixth statement, paragraph 73, he says in January 2021, Panasonic commenced an internal review of the potential liabilities relating to these proceedings. As part of this review, Ms. Hollow provided certain senior Panasonic finance team members.
Sorry, which paragraph?
Sorry, I'm going too fast, I know.
No, you're doing, no, we're doing fine. I've just missed the paragraph number.
Paragraph 73.
Thank you. Yep, thank you.
So they went to senior finance members in 2021, January 2021. But for compliance with the trial order, which called for a sign-off from a director, They did not. And the judge records the fact that these senior finance members ought to have been involved in the preparation of the Varna statement. That's his paragraph 51. They spotted the problem pretty well straight away. And what that means is that in January 2021, Panasonic was on notice that their own decision not to comply with the trial order had caused this significant error. In-house counsel knew that, but so did Panasonic solicitors, Hogan Lovells. We asked an RFI about this, to which the answer is they knew in January 2021. So Mr. Bennett says it was an error on my part. In January 2021, he knew what the consequences of that error were. They didn't tell us. Instead, they doubled down on the error by appearing in front of Mr. Justice Mann and telling him this material was highly sensitive because you could get their profit information from it. It had been designated external eyes only, and in February 2021, there was a hearing before Mr. Justice Mann about who should get to see this. And Panasonic put in evidence. If you go to tab 4 of the supplemental bundle, this is the evidence they put in for the purpose of restricting the circulation of the Varna statement.
I mean, I'm conscious you're under pressure of time, and we've read Mr. Justice Mann's judgment, which was in the bundle. I mean, please, if you need to,
yes.
But we are very conscious of what was in that judgment, what the issues were, and what the outcome was.
Very good. I just wanted to draw your attention then to the fact that Mr. Jennings is Executive Vice President, Office of the Chief Operating Officer of Panasonic. A rather more senior man than Mr. Varna.
Well, I think what we know that they shouldn't have used Mr. Varna. The judgment was highly critical of the fact that they did,
yes.
And they then had to bring in the big guns to sort out the mess.
But, my lady, that's not what's going on here. What's going on here is they are bringing in the big guns to assert before Mr. Justice Mann that Varna is true. But they knew from the previous month it wasn't. They were telling it, it's all the wrong way round. They breached the order by getting the little guy to deal with it. They then bring in the executive vice president to say, the Varna information, that's the crown jewels. You can get all our profits out of it, so you can't show it to anyone in-house at Lufthansa. And you will see that from Mr. Justice Mann's judgment. You've read it, so I won't take you to it, but it's behind tab 5. The complaint was that this information will enable Mr. Muirhead of Lufthansa to work out the profit margins of the defendants. By this date, Panasonic knew that wasn't true. It wasn't remotely possible to work out their profit margins because Varna gave a wildly incorrect indication of them. But they were content to put misleading evidence before the judge and to advance misleading submissions. The order that Mr. Justice Mann made is behind tab 6. I don't think you've seen that.
Date.
So it starts at page 44, but if I could turn you forward, please, to page 50. This is Annex 2. So there was a contest about who would get to review the Varna statement, and the judge has resolved the contest, and all these people are going to get to see it. What that means, of course, is that in February 2021, Panasonic knows that all these people are going to be doing work on the Varna statement, which they know to be wildly misleading. Mr. Jekyll, partner Jones Day Germany. Mr. Mandler, associate Jones Day Germany. Barclay Research Group, that's our forensic valuation experts. These are all high quality, high cost professionals, and they're going to be spending time working on the wrong figures, as Panasonic knows. and Panasonic still waited another 22 months before telling anyone. So they put in an inaccurate statement and sat back while all these people did work based upon it. And the deputy judge held that this actually made a difference to the hearing before Mr. Justice Mann. He said, counsel for Lufthansa made the fair point that the evidence for that hearing before Mr. Justice Mann would have looked very different if the evidence given by Mr. Bennett and Mr. Jennings had mentioned Mr. Duckworth's comments. In other words, had mentioned the fact that the profit figures were wildly wrong. Then from June 2021 onwards, I need to pick up a couple of points of what my learned friend said about this period. It's not right to say nothing was happening before we served the points of claim. We sent 3 letters chasing more recent profits information in March and April 2022, so it was clear to them that work was going on. My learned friend was also wrong to say that Panasonic wrote in September 2022 saying that they would be correcting their profits information. They didn't mention the need for any correction. They said they would update it, but that was all of a piece with our request for more recent figures, given the passage of time since Varna had been served. Now, I do need to then talk about or show you what happened in relation to the application itself, such as it was, because this feeds into one of my points about judicial disruption and cost. There's a good reason why it's incumbent on a party who is in breach or needs relief from sanctions to sort out the procedural consequences as soon as practical. It's because the sanction is liable to affect the path of the litigation, and the parties need to know the path that they will be following as soon as they can, because it's likely to exacerbate inefficiencies if they don't. And the learned deputy judge also referred to paragraph 2.7 of Practice Direction 23A. Every application should be made as soon as it becomes apparent that it is necessary or desirable to make it. I want to show you how Panasonic responded to their duty to sort this issue out. And this starts in the supplemental bundle behind tab 8. The position is that by this stage, Takahashi has been served the day before. This is a letter from my solicitors of the 9th of December. But there was no explanation for the new witness statement, so I think it might have been the 2nd of December. We wrote this letter the following week, and we can pick it up at the bottom. Now that Lufthansa has made its election, it's not open to Panasonic to retrospectively change in a material way its revenue and costs information. Indeed, it's not open to Panasonic to advance a materially different factual position to that set out by Mr. Varna. Over the page, if you want to rely on the Takahashi statement, you will need the permission of the court. Panasonic did not reply to that letter, so we wrote again a month later, and that second letter, I'm afraid, is towards the back of the bundle, tab 32. Second paragraph, we repeated our position that Panasonic needed to apply, and pointed out that the application will impact the procedure and conduct of the case going forwards, so it's obviously sensible for this to happen now before other steps were taken. Now, the response from Panasonic is behind tab 9. If you could turn forward, please, to page 65. Could you read to yourselves the first full paragraph beginning, we note that you say it is not open. So a flat refusal to apply to the court in the face of our assertions as to the procedural problems that will pile up if they did not. And it was in response to that that we seized the initiative and made our own preemptive application. In our letter accompanying that application, we explained that Panasonic needed relief from sanctions. You don't need to turn it up, but it's behind, it's on page 327 of the bundle, tab 32. Still no application. And you see the substance of the position recorded in the judgment. I'm not quite going there yet. Yes, well, paragraph 21 of the judgment. Our preemptive application effectively reflects the provisions of 3121. We applied for an order that Panasonic may not rely upon those additional costs and deductions referred to in the Takahashi statement. And as you'll see from the following paragraph of the judgment, it is this application by the claimant which led to the present hearing being fixed. And it was only our application to the court that prompted Panasonic to issue its own application. If we hadn't done this, this issue would still be unresolved today. Now, these materials give a bit of context for the apology that was proffered in my learned friend's skeleton. You'll recall that paragraph 6 begins a somewhat incomplete catalogue of Panasonic's procedural breaches, and it ends by saying, all of this is deeply regrettable, and Panasonic apologises to Lufthansa and the court. This, we suggest, is entirely synthetic contrition. There was neither a hint of apology nor even cooperation at any time before we issued the application. This is simply a response to the hearing going the wrong way at first instance. Now, the final conduct issue we draw to your attention relates to Panasonic's evidence. And you will have seen from the judge's judgment, paragraphs 54, 61, 63, 66, and 68, that he was repeatedly moved to criticise that evidence. And there's nothing in my learned friend's appeal to challenge those findings. He said important questions were left unanswered. He made two particular complaints about the hearing in February 2021 before Mr. Justice Mann. This is the Deputy Judge's paragraph 61. First, he says Mr. Bennett has not explained how he had been able to give the evidence that he gave before Mr. Justice Mann in February 2021. And the judge will have had in mind that Hogan Lovells knew about the Varna issue the previous month. And second, he says that Mr. Bennett has not explained why his evidence on this application did not even mention the evidence in February 2021. So the judge is saying, you haven't explained why that happened, and you haven't explained why you didn't mention it. And these are all matters of conduct which the judge was perfectly entitled to take into account in relation certainly to Denton Step 3 and to the good administration of justice. I'm grateful for you bearing with me for that recap, and I'm going to move now to address the grounds of appeal in terms. The first one is whether this is a sanctions case at all. We say there are two bases upon which it is, and I've largely trespassed on those already. The first is CPR 3121, and I've shown you the parts of my learned friend's skeleton where they accept that they were under disclosure duties, and we say that those can only be Part 31 disclosure duties because there's no other part of the CPR that imposes such duties. You don't get to pick and choose your duties once Part 31 is engaged, it is engaged with full force. My learned friend in his oral submissions provided, I think it was 4 reasons why Part 31 was not applicable. First, he referred to the fact that there was a split trial. Sorry, that's not quite right. I think this is why the order of Mr. Justice Arnold was not applicable. So Mr. Justice Arnold made an order disapplying the new, what was then the disclosure pilot, from the proceedings, not from the liability stage, but from the proceedings in general. That's what the order said. My learned friend said, well, that doesn't matter, because firstly he said it's a split trial, and he said that the order was only for disclosure only governed disclosure in the liability stage. We don't accept that the trial order of Mr. Justice Morgan was not governed by the order of Mr. Justice Arnold, as he then was. It was part of the liability relief. It's part of the liability stage. It makes no sense to say, well, that order governs what the trial, but then on the last day of trial it stops. Plainly it carried on. It would have covered the liability relief hearing, and indeed it would have maintained during the appeal, because of course it's well established that disclosure duties maintained during the appeal. That regime was probably impliedly displaced when the quantum stage began. But the quantum stage only began with the points of claim. The election and the points of claim came on the same day.
I'm not sure I do follow why any of this matters, really.
My learned friend wants to escape from Part 31, and so he wants to say that Mr. Justice Arnold's order, which imposed Part 31, was no longer of application when Mr. Justice Morgan made the trial relief order.
I suppose I may be saying I'm not quite clear that this point made
Yes.
by Mr. Purvis matters, but I mean, so be it in general terms. You say, well, Part 31 still applied, but no one thought that this was an order for disclosure of documents under Part 31.
I wouldn't accept that in its entirety. So I would agree that no one thought that there was going to be an utterly conventional list of documents provided, followed by inspection, because plainly that wasn't what was ordered. But what was ordered was another route to the same information. It was in lieu of that entitlement to disclosure that the judge ordered a witness statement. And because that witness statement was to replace the slightly more archaic approach of a list of documents, the obligations that police, or would have policed, the list of documents also police the witness statement. And so much of that is common ground, as I've shown from my learned friend Skeleton. It's as if they accept the duty of disclosure, they accept a continuing duty. The only one they balk at is 3121. So if I can turn the question around, I would ask my learned friend, why all the other parts of Part 31 and not this one? What is it that stops this sanction from applying, given that you've got a continuing duty? Because the rules, those drafting the rules, have plainly thought that this scheme is a good and appropriate one, and indeed you're required to consider it to be compliant with the overriding objective. So why does 3121 suddenly become inappropriate, given that all that's happened is the judge has chosen a more cost-effective route to the provision of that information?
It's not just cost-effective, is it? Because if you have a list of documents followed by inspection, then subject to any supplementary lists and all the rest of it, they have a complete picture which allows them to get their accountants and everything stuck in to produce whatever they need to produce to analyse it, check it, and see whether it's accurate. What's happening here is nothing like as firm or complete as that. It's only sufficient information as to enable the election, as I understand it. So
that's not quite right. No, it's well.
No, have I got that wrong? It's
well,
not.
So there's a two-stage process. The judge has to consider what evidence is reasonably necessary and appropriate to enable an election.
Yes.
But he's done that process and enshrined the outcome of that exercise in paragraph 10. So that was a decision for the trial judge. What is reasonably necessary? He decides that and he says, you shall provide this witness statement. And that witness statement is in lieu of disclosure.
Because it's never going to be as complete as a full list of documents together with disclosure.
So, for example, you might have disclosure of management accounts rather than full invoices. There are a number of ways that this sort of information could be given as old-fashioned documentary disclosure. But it is, in the computer age, financial documentary disclosure involves hundreds of millions of documents, and that's not convenient. The same information comes out of it, but it's not, and it's also not particularly easy to interrogate. So instead of requiring an Excel spreadsheet of 5 terabytes, you get a document, a witness statement from someone who knows what they're talking about, who's senior, who can give you the information.
So just so I'm clear, you're saying that you have as good a quality and detailed in summary form in a witness statement as you would after full disclosure.
No, I'm not saying that. I'm not saying that. The information doesn't have to be as granular, but it does have to be accurate. Now, in certain circumstances, that accurate general information might be easily available in a document. And Panasonic could have said, we've got summary documents for this particular business, which will give you precisely what you need. And we turn one out every year, we can give you 3 of those. And the judge would say, fine, you will disclose those documents. But as it happened, there was an alternative route to the provision of that information. But information is what this is all about. And the fact that Part 31 bites on documents is a slightly archaic proposition. Of course, it now also bites on electronic documents. But electronic documents it's a bit of a fudge. They're not documents at all. They're bits of memory. They're ones and zeros on a hard drive or on a flash drive or something. And it's only they are extracted and turned into something. They're generated into something that can be interrogated and interpreted. But what's actually going on here is the provision of information. So whether it's in a document or an electronic document or a witness statement doesn't affect the underlying obligation, which is to provide an accurate picture of the profitability of this business. My lords, that's why I say there's an express sanction. But if I'm wrong about that, then there is an implied sanction for much the same reasons. Because even if this wasn't an order for documents, it was an order for provision of information that could have been in documents. It's accepted to be in lieu of disclosure. It's accepted that disclosure duties applied. Well, if that's right, then policy, good policy, would require that just as Part 3121 polices the disclosure duties for documents, the judge's sanction provided precisely analogous policing of the informational duty in paragraph 10 of the trial order. And because the court is required to consider that 3121 is compliant with the overriding objective, it necessarily follows that a corresponding sanction for the provision of information in lieu of disclosure must be justified. the only way you can avoid that conclusion is by disapproving in some way, implicitly if not expressly, of the regime that includes 3121.
They're not necessarily the same, are they? At least as expressed by Mr. Varner, he wasn't claiming to be precisely accurate.
No. It's not about what Mr. Varner was claiming, it's about what Panasonic were obliged to do.
And so to be clear, you say it's implicit in the island records regime that you have to be exactly accurate.
No. You don't have to. Perfect accuracy is not required.
But if you're inaccurate, it can only be one way.
Yes, you said that earlier on.
Well, so let me take that. There are two parts to that. The obligation in paragraph 10, as the judge recorded, it hardly needs saying that the information supplied pursuant to this order needed to be accurate. It's a court order for information. It has to be accurate every which way. Not perfectly accurate, because there's a context for the interpretation of that order, which is it's got to be fit for purpose, accurate enough to do the job. Common ground, I think, it wasn't. We're not dealing with rounding errors here. We're dealing with an utterly inadequate response to the order.
Well, can I just try to see whether there is a point there? Is it your case that the implied sanction was you cannot make any corrections at all? Or is it your case that you couldn't make any major corrections?
So it's my case that the express and the implied sanction is that you cannot rely on your own corrections without the permission of the court. So there is a hard sanction, but it's ameliorated by the application of the test, the Denton test. So if you're talking about a rounding error that was swiftly corrected, there's no doubt that permission is going to be granted. It is only the combination of the extraordinary extent of the error and the extraordinary length of time taken to inform us, and all that went on in the meantime, that gets us to this position. This is no question, this is an outlier, because these sorts of mistakes would not normally take place at this size or with these consequences.
And just one further supplemental point. We touched this morning on the question of corporate taxes. Mr. Varner said corporate taxes of
22.
far much larger sum than
22
Mr.
million versus 7, I think.
Hashi found.
Yes.
So come the hearing of the account on your case, is Panasonic allowed to assume that it incurred corporate taxes of a larger figure, even though it didn't?
So I think the answer to that is that we're starting in the wrong place. We're starting with my learned friend's figure of 30 million and asking, well, what happens to this when you're looking at taxation? And at the moment, I don't know what the answer is. What the answer
is the other way around.
Is the 30 million's the wrong
It's the other way around, is what happens to the taxation
well,
if you're excluding the 30 million?
Perhaps I can answer it in a different way, which is there is a number which will represent the difference between what would happen in an account under the Varner statement or under the Varner deductions and what would happen in an account under a Takahashi, with Takahashi deductions. And there's a divergence between the two, and that divergence will need to take into account, well, it's going to be resolved.
But you're not going to be allowed to rely on that.
No, I'm saying notionally, if we went off and had two trials, they would if no relief from sanctions is granted, we're stuck in a Varner world, we'll end up with an outcome for a trial. If we notionally went off into a Takahashi world, there'd be a different outcome, and there will be a difference between the two.
So are they allowed to take into account in the accounting process tax that they have not paid or incurred?
I think the answer is that the 30 million is probably the wrong figure, because the 30 million assumes some changes, but perhaps not all the necessary changes, one of which may be the tax figure.
But, sorry, can we just strip it back? Assume that the sales credit,
Yes.
let's simply take the sales credit.
Yeah.
That, whether you include that or not, obviously has an effect, or can be expected to have an effect on how much tax you pay.
Yes.
So if you say they're not entitled to take into account the sales credit, that, on the face of it, has an obvious implication for the tax.
Yes.
You say you benefit from the fact they can't take into account the sales credit. Are they allowed to say, well, if we're not allowed to take into account the sales credit, we can take into account tax that we have not incurred, because it's a consequence of the sales credit?
But that would be to deduct tax that they haven't paid.
No, quite.
Yes, but you're
Right.
getting 30
Yes,
million.
which is why. Well, sorry, which is why I'm saying the problem's actually with the 30 million number. It's probably too low because it doesn't take into account, because it builds in tax that they haven't paid.
So they are penalised twice. They're not allowed to take into account the deduction, but they can't claim to take into account the tax that they would have paid had there not been a deduction, because they haven't paid it.
I don't think they're penalised twice. What they're not allowed to do is claim a deduction for tax they didn't pay. So what they have done is they have made a mistake in their calculation of the difference between Varna World and Takahashi World. Because in their calculation they have not realised that there was a tax change as well. So it's not a double double deduction. What it is you can't mix and match the tax you actually paid with the tax you would have paid.
But you are sort of mixing and matching, because Mr. Varna says, look, I'm going to assume a certain rate of tax and apply it to the profit figure I've got. That's how I get to this tax figure.
Yes.
But now it turns out, according to Panasonic, that was the wrong profit figure. But they're not allowed to say, even, look, we'll just apply the percentage to what it would have been.
But that's because that was another error in... Effectively, there were two errors in Varna. He overestimated the profit, and as a result, he overestimated the tax. It's not double anything, it's just two related errors, only one of which my learned friend has given voice to until the question was asked. One of my learned friend's arguments in response to the interpretation of the rules as I've given voice to them is to say, well, look, what would happen if we hadn't served any statement at all? They say the only effect would have been to have delayed Lufthansa's ability to make such an election, but as I think I've touched on already, that's not right. If they hadn't served any document at all, provided any disclosure, assume I'm right about the Part 31, then the permission they needed would be that much more extensive. They would need permission to rely on all the undisclosed deductions, as opposed to just the deductions that were missed off from Varna. So they are in a better position.
But paragraph 11 had liberty to apply for further directions and implementation of paragraph 10.
Yes.
So are you saying they would have to go from straight on to making an application for relief to sanctions, or would the appropriate application be to make an application under paragraph 11 for an extension of time, or for you to apply for an unless order with perhaps penal notice? Are you saying actually, really, paragraph 11 has no teeth, because what this is all about is always relief of sanctions, and you ignore paragraph 11?
The law, as I understand it, is if you're given a deadline for witness statements or a deadline for disclosure, again, assume this is documents, and we'll park that argument. If you're given a deadline by which to comply, anything that's not included, witness statement or a document, will attract the express sanction of 3210 or 3121. Now, if you correct the position swiftly, there's no question.
But the answer to my question is paragraph 11 is actually OTOs.
No, paragraph 11 may, if you applied before the deadline, say they were given 14 weeks to do this. They could say, look,
apply for an extension of time.
an extension of time, or turns out that this is really hard, can we amend it? But
what it wasn't there for is you couldn't then have applied for an unless order, because you would be saying, tough, claim over.
No doubt, if there'd been complete non-compliance, I could have applied for an unless order, depending on what the explanation was. But it's absolutely right that in order for this process, which is intended to save time and money, the island and train process, in order for this process to work, there needs to be a degree of cooperation. Mm-hmm. But it doesn't get it out of the regime, which is deadlines need to be complied with. Minor breaches aren't going to be a problem. So we mustn't get all caught up in, gosh, isn't the sanctions regime hard? Can it really apply here and there? Well, it's meant to be hard so that people comply with the deadlines, but minor breaches will always be susceptible to relief. So I don't shrink from the proposition that, yes, that is an application. Now we're coming on to consider my learned friends, what happens if my learned friend's right and the judge took the wrong approach? This isn't a sanctions case. What do you do about it? Well, you're applying the overriding objective in the circumstances of this case. This is his new point, and I've explained why, in accordance with the reasoning of Lord Dyson and of Mitchell and Denton, there isn't a great deal of...
you say get to the same result anyway for the same reasons, but they're under wearing a different hat.
Absolutely not in most cases, but when there has been a serious and disruptive procedural breach of a court order, that is likely to be the position. But if you entertain his new point, you're going to have to carry out this assessment yourself. And my proposition was that the cost of not having raised the point before the deputy judge must be that you then do this assessment today in October and not back in April, because we are where we are, and the procedural ramifications must be judged today, particularly given this wasn't a point Panasonic chose to take before the deputy judge. My learned friend says, oh, you haven't put this and that in your respondent's notice. It's a new point. It wasn't before the court below, so it's not the province of a respondent's notice. So I'm going to explain to you my position, which mirrors that before the deputy judge, of what would happen now, how disruptive is it, given we are where we are. Well, the first consequence that I lay at his door is the sanctions hearings themselves, and I'll explain why. There are two reasons. First is because they refuse to apply, and the second is the uncontested position on Denton steps 1 and 2. So let's start with the refusal to apply. I've shown you the correspondence. Takahashi was served in December 2022, and they refused to do anything about it. Their position was, we don't need to tell anyone, we don't need to tell the court about all our misleading evidence, about any of this. So we had to draft and issue draft evidence, application. That's all work we had to do. That's not about relief from sanctions. They forced that upon us by not doing anything at all. That was in accordance with our duty to assist the court in its case management. And as the judge said, it was this application, the preemptive one, that was what brought this whole matter before court. So there's no sort of break in the chain of causation, if I can put it like that. From the Varna breach, we're told about it, our application, we get to court. They can't say, oh, well, that's a circular argument because that's a sanctions hearing. It wasn't a sanctions hearing at all. They never applied. What it was a consequence of their breach, and therefore all the judicial work, the time at the court associated with it, is to be laid at their door. But it's not just that hearing, it's this hearing as well. So we've had the deputy judge who had a day in court and then gave judgment the next day. We've had Mr. Justice Arnold considering permission to appeal, reading all those papers. Your Ladyship and Your Lordship pre-reading for today and today's hearing. It is right and proper for that all to be considered a consequence of the Varna breach, because they didn't try and get ahead of the problem and sort it out. And this sort of time, this is 3 judge days, 4 judge days plus the pre-reading, is out of all proportion to the sort of disruption that caused, for example, the Clearway case to be thrown out. That was 2 adjourned PTRs. All this time, we could be doing other things, you could be doing other things, is because of the Varna breach. And it's perfectly proper to attribute it to that. And I invite my learned friend to say why there's a break in the chain of causation of judicial inefficiency, of litigation inefficiency between that breach and us being here today. The second reason, the uncontested position on Denton steps 1 and 2. What that means is that if this is a sanctions case, it was unequivocally appropriate for Lufthansa to require Panasonic to apply for relief from sanctions. In the Denton case, you will recall Lord Dyson and Lord Justice Voss disapproved litigation opportunism in this context. This is the antithesis of that. They lied to the court repeatedly, let alone us. It was their job to come and sort it out, to come and explain the true position. They didn't. It was appropriate for the court to scrutinise an application for relief from sanctions, given the evidence that was put before Mr. Justice Mann. And as for step 2, well, you're aware that the court has been consistently unimpressed with explanations as to why a breach took place. But based on our researches, this is an unprecedented case where the explanation is an aggravating factor. This is paragraph 79 of the judgment. I had to consider why the failure or default occurred. The answer is simple. It's because Panasonic chose to give the job to someone who was not merely unqualified to do it, being too junior to give the correct evidence, but who was not even permitted to do it under the order. I accept Lufthansa's submission that this means the breach of failing to meet the deadline set down in paragraph 10 of the order arose because of another breach of the same order by Panasonic. So the answer to Denton step 2, which is meant to be exculpatory, is we made another breach of the same order. It's a fairly extraordinary position. And as a result, even if this is not a sanctions case, the same analysis applies, because any other outcome would be to utterly disregard subparagraph F of the overriding objective. These hearings involve, 73 pages of documents now, 78 pages from us, 58 pages from Panasonic. There's a huge amount of work that's gone into this. All of it properly set at their doors. I want to move on to the contingent question, litigation inefficiency and a new election. Panasonic rightly accepts that the price of getting the Takahashi statement in must be that Lufthansa is given another opportunity to elect. My starting proposition on this point is that it is for Panasonic to establish that there is no realistic prospect of Lufthansa responding to a further election by choosing damages. And if they cannot do that, the consequences of a changed election must be weighed in the balance of this application. And they have 2 bases for saying Lufthansa will not change its election. The first is, they say, we declined an opportunity to re-elect in advance of the hearing before the deputy judge. And the second is that we have not committed to our contingent position in evidence. So I just want to deal with those 2 points. The first is the one that attracted the judge and is the subject of our respondent's notice. And for your note, this is paragraph 95 of the judgment. The judge said he was struck by the powerful point that even after the Takahashi statement was served, Lufthansa was given a chance to re-elect and declined to do so. That analysis misunderstands the re-election offer. It is an offer to elect between Takahashi profits and damages. And one can only engage with that offer by first agreeing to the admission of Takahashi. It only makes sense in that context. Well, Lufthansa does not accept that Panasonic has a good case for the admission of Takahashi. and our position to that end was upheld at first instance. So what that means is that the rejection of the offer tells you nothing more than that that Lufthansa would prefer Varna profits to Takahashi profits. Well, so it would. But it is no guide as to Lufthansa's attitude towards an election between Takahashi profits and damages. The answer to the second point, that we haven't committed to our contingent position, is that we're not required to, and my client has declined to go into print on a hypothetical election. Now, my learned friend wants you to draw adverse inferences as a result of that, but we say that's not appropriate or justified because the question is procedurally unfair. It comes loaded with a conflict. Lufthansa has a stated preference for Varna profits, and it would assist in achieving that preference if they were to commit hypothetically to electing damages if given another election. So it's an unsatisfactory, conflicting question. If you promise you'll choose X, you can get Y, when Y is what you want. So for those reasons, we say you shouldn't draw any adverse inferences. It's not appropriate to require a party in Lufthansa's position to decide that sort of hypothetical question in those circumstances. We also have a positive position on why a decision on the election is uncertain, and that is found in recent developments in the account. My learned friend referred to this. They've now pleaded a positive case on the facts about a non-infringing alternative cause of action. They say, well, no profits are recoverable because we would have made all these same profits with a non-infringing widget. And that's a new defence that's only recently become added by amendment. Obviously, the defendants think it's worth advancing. That's why they've pleaded it, notwithstanding the massive disclosure burden that will accompany it. And we say, well, that's something that Lufthansa would take into account as making the profits position a bit more perilous. Now, in their responsive skeleton, my own friends have jumped on this point, saying, well, that means the offer to re-elect is beneficial to Lufthansa. They get the chance to change their mind on the basis of new information. But that's true, but it's missing the wood for the trees. If we were to elect differently, that would conclusively establish that Panasonic's breaches had caused enormous inefficiencies in this litigation and beyond. Let me explain what those would be. There was another case management hearing in the accounts, these three accounts, on Tuesday of this week. That takes the current tally to 5 hearings, 5 court days, 3 days of pre-hearing, 3 days of pre-reading, 5 judgments on contested issues. And we have another pair of procedural appeals coming before this court in 2 weeks' time. 77 pages of pleadings, 262 pages of evidence in these accounts. And this work is not all common to all 3 defendants. More than 5% of the pleadings are addressed exclusively to Panasonic. And if we now switch to damages, that's all wasted. All wasted time, wasted case management by judges, because we've been proceeding with the wrong choice in light of the Varna statement. And then going forward, the disruption becomes even worse. We couldn't have a damages inquiry ready for this time next year. I think we'd have to, well, obviously we need a judgment from this court. If you grant relief from sanctions or overturn the first instance judgment, we then get another election, and then pleadings have to start anew. So I think it's most unlikely that we keep the current trial date for a damages inquiry. But even if we did, there's duplication, there's delay, because rather than hearing 3 accounts on the same basis, the judge would be hearing 2 accounts in a damages inquiry, very different considerations. I mean, there are some similarities, of course, but I think the result would be either a delayed single trial with additional complexity or the current trial date would carry on for the two accounts against the other two defendants, and there would be a later damages trial against Panasonic. So we do not accept that this behaviour would not have an effect on the trial date against Panasonic. My lady, my lords, those are my submissions in relation to ground 1. I can move on to ground 2, which is very, very much quicker. The purportedly incorrect approach to step 1 of Denton. My learned friend says that Denton step 1, it is common ground that Denton step 1 requires the relevant breach to be either serious or significant, and he accepts that it was serious. So it's somewhat academic whether it was also significant too, but he's clearly wrong on the law in relation to this, so let me show you. The easiest place to see it is from my learned friend's skeleton, which is, if you could take that please. Paragraph 62. So this is the law, and he sets out at 61 a quote from Denton, and the propositions he takes. First one is that it is necessary to consider both seriousness and significance, and then insignificance is akin to immateriality, which means a breach which neither imperils future hearing dates nor disrupts the conduct of the litigation. We don't think any of this is right. It starts with a strict distinction between seriousness and significance, and the proposition is that significance refers exclusively to consequences of the breach. You simply can't get that from Denton. If you take the authorities bundle, just to give you the history, it starts in Mitchell, and in Mitchell the word trivial was used together with the antonym insignificant. And then in Denton, which is authorities tab 5, turn forward please to paragraph 24. My learned friends quote from the middle of paragraph 24, about 5 lines down: the first stage is to identify and assess the seriousness and significance. And they stress and highlight that and. But if you just look at paragraph 25, which also deals expressly with the first stage, it is now to identify and assess the seriousness or significance. There is no justification for the emphasis my learned friends place on the conjunction and. All that's happening here is that serious and significant are being used together to give a bit more colour to the description of the test.
So I'm just going, where was the or?
The or, do you see the first line of paragraph 25?
Oh, 25, I'm sorry. That's
yes.
Right.
Under the heading the first stage.
Mm-hmm. Actually, that's consistent, I think, with the sentence just below G, if the breach is neither serious nor significant.
Indeed. Mm-hmm. But this isn't a statute. Paragraph A, serious, paragraph B, significant. But it's not even consistent with the paragraph that my learned friends quote in their statement, in their skeleton, which comes from paragraph 26. You see that in the middle of that paragraph, it was submitted on behalf of the Law Society. The test of triviality should be replaced with the test of immateriality, and that an immaterial breach should be defined as one which neither imperils future hearing dates nor otherwise disrupts the conduct of litigation. Provided that this is understood as including the effect on litigation generally, and not only on the litigation in which the application is made, there are many circumstances in which materiality in this sense will be the most useful measure of whether a breach has been serious or significant. So even in the passage they quote, that distinction is not honoured. And of course this is a non-limiting passage in many circumstances. It doesn't even tell you that the consequences are the be-all and the end-all. They're not. They will be in many circumstances, the most useful yardstick. As to the application to the facts, we don't accept in any event the assertion of insignificance, even if they were right. It's our position that there was a continuum of breaches, disclosure breaches, from November 2020 until December 2022. And we understand this to be common ground, actually, from my learned friend's paragraph 60, which footnotes the judge, in particular the judge's finding that Panasonic has on any view taken far too long to provide an accurate witness statement. This wasn't a single incident of breach that the judge found. He relied on an extended period of breach, which is accepted to be serious. But we say the Varna inaccuracy breach is also significant on the basis of a narrow construction of the word, and that's because it frustrates the procedural efficiencies which are the object of the island and Tring approach. And I explained at the outset that the extent of the deviation between Varna and Takahashi meant that Varna was not fit for purpose. Panasonic's inaccuracy breach meant that Varna was not a reliable basis for an election. And the judge expressly relies on that factor in his paragraph 76. So this is when he's dealing with Denton step 1. So he says, picking it up in the middle of 76, Panasonic's taken far too long to provide an accurate witness statement in circumstances where it is known since January 2021 that the original witness statement was inaccurate to a significant extent. And then the very next sentence, in my judgment, that is not something which the court should treat as other than serious or significant. He's saying, he's expressly relying on the extent of the deviation, and he's right to do so. That's ground 2. Ground 3, my learned friend complains about the misapplication of Denton step 3. He says this is a short, in his skeleton, short but powerful point. This is paragraph 72. He says, one important factor to consider is whether the sanction imposed is proportionate to the breach. Is it an important factor? It's certainly amongst all the circumstances of the case, but there's no authority cited for the proposition that it has particular importance. And we say it must be wrong, because we know what the important factors are from the rules and the guidance in Denton. The important factors are the two listed in Rule 3.9. Efficient litigation is the first, rule compliance is the second, and they in turn lead the court to place particular weight on the seriousness and significance of the breach and the explanation for it. Prejudice to the breaching party plays at most a secondary role, and that analysis accords with the reasoning of Mr. Justice Trower in the Syed and Shah case, which we set out under paragraph 87 of our skeleton. He explained why it was wrong in principle to look at the position between the parties only and say that as between them, the result is disproportionate. That is exactly what Panasonic is doing under its ground 3. Moreover, as we've seen from Mitchell and Clearway, any proportionality argument must be approached on the assumption that the sanction provided by the rules is proportionate. So if you're with me on part 31, that sanction, your starting point is, it is right and proper for the sanction preventing reliance on documents to apply. And it is for the party seeking to escape that sanction to justify doing so. And it seems to us that that consequence is entirely consistent with the express sanction. If you didn't disclose these costs, you can't rely on them. The logic is impeccable. My learned friends then have particular criticism for paragraph 84 of the judgment, where the judge held that although the prejudice to Panasonic was significant, that was a good reason why they should have got their evidence right in the first place. There's nothing wrong with that reasoning. It highlights the very tension I've already alluded to, that the assertions of prejudice are counterbalanced by the gravity or significance of the breach, the extent of the deviation. A £30 million breach, 30 million reasons why you should have spotted it when complying with the trial order. And the final passage the final sentence of paragraph 73 of the written argument on this point is also important. They say, the judge's reasoning assumes that Panasonic should have anticipated the relief that is being granted. Well, we don't think that's any part of the judge's reasoning, but if it was, it's not a bad point. The relief that the judge granted is the relief set out in CPR 3121, so it should have been anticipated. And this was, in substance, reasoning approved by the Court of Appeal in the Chartwell case. Let me just, I think I have time just to show you that quickly. So it's Authorities Bundle, tab 3, paragraph 51. Lord Justice Davis is dealing with the question of whether the prejudice to the claimant, the defaulting party, is significant, and he decided it was significant in that case. But there's an important passage at the end. It says, that therefore is a relevant circumstance, in my view, and that is so even if it can forcefully be said that such a consequence was at least foreseeable in this case, in the event of non-compliance, and should have meant that there was all the more reason to comply in the first place with the order for exchange by the stipulated date. That's in effect the reasoning my learned friend says is erroneous in the judgment. I don't think it's even think it's in the judgment, but it would be perfectly proper if it were, because the consequences are set out in black and white in the rules. That brings me to the windfall point. My learned friend says missing out on a windfall is not appropriate prejudice. Again, we don't accept that's what the judge did, and that's because this isn't a simple windfall case, and that emerges when you consider the proper context of it. There was a court order requiring Panasonic to provide accurate information so that my client could review it and elect upon it. Lufthansa spent significant sums on an array of professionals for the purposes of reviewing that information and advising upon it, and Lufthansa then made their election relying on that information. They incurred further costs in progressing the account, so there is something akin to an estoppel here. Panasonic now wants to wind back the clock, notwithstanding all that expenditure, that reliance, that detriment. It's not right to say that this is some sort of adventitious benefit falling into our lap. They willingly represented that this was their profit position for the purposes of an election which then took place and the reliance that followed. If permission is granted, Lufthansa will face a more procedurally complex future, a re-election, perhaps a damages inquiry, a more complicated account, and perhaps a lower value claim. But there's nothing wrong with the judge considering those factors to be of some weight. We had a legitimate expectation in this litigation that the order had been complied with. The final point, I'm not sure I really need to deal with. I didn't detect a great deal of enthusiasm from my learned friend on the failure to consider the legal consequences. It was an argument that was rejected in Denton at paragraph 56, but in any event, the judge did consider whether costs would be adequate, and he decided that they would not. My lady, my lords, unless I can help you any further.
No, thank you very much. That's most clear and helpful. Anything in reply, Mr. Purvis?
I just had, I think, about 5 short points. most of which I can just give my lady my lord's references to, and on the assumption that we may reserve at least a
I can't believe why you think we might do that.
to have a look at rather than go to. There were a couple I would like probably just to go to.
Certainly.
First point was this question, and that's the only point I want to make in reply about the Part 31 argument, where my learned friend said that what's going on in Ireland records is something akin to disclosure, and that you may remember in my submissions I suggested actually in many ways that the order made for Ireland Records statement in paragraph 10 was quite akin to an order for a pleading because of the nature of the language, in particular what Panasonic would seek to claim. And I was reminded that my learned friend himself below at tab 23, page 269, did make that very point himself. Whether you need to turn that up, but I could just read it out. He said there, that's 269 of the bundle, and it's at the top of page 109 of the transcript at line in lines 4 to 10. A short point about Takahashi, and then a friend presents it to the court as if it's undisputed. Undisputable, that's not how we see it. In the event it comes into the case, deductions are likely to be contentious. In effect, it's something akin to a statement of case. So it's not our position that Takahashi will be without challenge. We submit that's a fair recognition of the nature of the direction in this case.
That's Takahashi rather than Varma, isn't it? He's talking about.
He's talking about Takahashi, but again, it's the consequence. Either is the consequence of the order. We would say the same must apply to both. There's no material difference between them so far as that point is concerned. Another made a point about the substantial time he said was spent on Varna by lawyers and internal witnesses. He didn't give you references in the evidence. Actually, it was only dealt with briefly, but Mr. McCulloch, when he gave his witness statement below, did in fact fairly deal with the number of hours that had been spent on Varna. It's at the supplemental bundle, tab 13, page 83, paragraph 27. And essentially it was 60 hours of lawyer's time and 30 hours of his internal witnesses. But your lordship's lady can look up that. We say in the great scheme of things, that's pretty minor, and there was no attempt by Mr. McCulloch to say how much of that had actually been wasted. The judge, of course, made the point that much of it would have been useful anyway. I did want to deal with some points my learned friend made about conduct. I didn't want to come back to it, but he did on some occasions go beyond a fair characterisation of what had happened and the judge's findings, and indeed in the heat of argument I think went beyond what had previously been alleged or found, even going so far as to accuse Panasonic's witnesses of lying to the court. We say that
I noted that obviously the word lie was used this afternoon, and I did wonder whether that had been part of their case throughout.
I certainly didn't. I didn't mean to intend. I didn't mean that there was an intention to mislead.
You used the word lie.
I did. So if I could correct that, I would like to withdraw that remark. That the intention was that there was information put forward that was known to be inaccurate.
Thank you very much for that concession.
I'm grateful for that. There was a separate suggestion that Mr. Bennett actually knew that the figures were wrong in January 2021 when he gave his evidence before Mr. Justice Mann. I would submit on the evidence in the that was put before the judge below, there isn't any basis for that allegation either. And you probably just need to look at, and I'll just give you the reference, tab 17, paragraph 74 to 5 of Mr. Bennett's evidence below, page 119 of that bundle. The position was that, as I opened, that there was a concern and a preliminary opinion of one person who had looked at it, but certainly there was no knowledge that those figures were wrong at that stage.
Well, we see what the judge said about that in his judgment.
Yeah, and the judge made the findings that he did, and
Yeah.
we don't challenge that. But we say that's going too far. And the criticisms of what Mr. Bennett said about Mr. Varner's figures being confidential, again, if you look at what Mr. Bennett actually said, paragraph 16 to 17, tab 3, page 21 of the bundle, we submit there's absolutely nothing wrong with that statement. Those figures did include accurate information on revenue costs and direct costs, which would plainly have been useful to competitors. Of course, we don't ask you to, we don't challenge in any way the judge's findings that at that stage we should have been telling the court about the possibility of error. One point on that I was reminded of, which is another strange consequence of the judge's order in respect of the customer incentives and our ability to bring those before the court. I referred to the fact that Lufthansa had amended their pleading, and in tab 12 of the core bundle is the points of claim. In paragraph 14a(b) at page 116, you will see a lengthy new pleading which alleges a claim for profits from what's often called convoyed goods in this field. In other words, sales that were made off the back of the infringing items, and they're claiming profits from those. So these have all been introduced. Is that not right?
No.
Well, before we all get into some satellite litigation in the body of the court, do we really need to go to deal with this?
We may not need to. The only point I'm going to make is that there are new claims here, which may well, if one's going to get to the bottom of them, have to involve looking at customer incentives, which of course is the one thing we want to mention.
I don't think that's somewhere we need to go to.
I don't think we need to go to that. On the law, my learned friend's mantra, if you're given a deadline, 3.9 applies, which was essentially, which is a direct quote, I think, summarises his approach. I would just repeat that's completely contrary to Lord Justice Moore-Bick's judgment in Salford, tab 6, page 86a, and the passage I took you to in opening. Turning to the question of the appropriate course so far as ordinary discretion under 3.12a is concerned, my learned friend characterised the test as being whether there were seriously disruptive breaches. We would say that's plainly not what the judge thought, given the passages in his judgment that I've taken you to. My learned friend said, oh, well, that didn't need to be challenged by way of respondent's notice. We say, clearly it did. This was a point that was absolutely an issue below. And indeed, the fact that we were going to be contending that 3.9 didn't apply, 3.12a was of course flagged up in our notice of appeal. On the election, again, my learned friend has simply not dealt with the question of why you can't tell the court if they're going to go.
Well, he has. He's given us his explanation as to why it's not appropriate.
Yes. What he won't do is say
No.
what the position is. Can I just say one final thing about his submissions on trial date?
Yes.
It's a slightly convoluted story. Before the judge below, Lufthansa's skeleton conceded that the trial date was not imperilled. In argument below, which is in the transcript 251, but again I won't take you to it now, you'll see what was said at page 36. My learned friend corrected his submission, said he thought it was going too far and that it could be under threat. But the judge then made a finding against him on that point, and we say that needed a respondent's notice to be challenged. Things have moved on in timing terms since then, but there is literally no evidence before the court, including by way of Mr. McCulloch's evidence in this appeal, to suggest that there is a difficulty meeting the trial date, whether we go for damages or profits. And the judge did consider either possibility. My lady, my lords, I'm sorry I've trespassed beyond the allotted time, and I'm most grateful.
Mr. Birss, you didn't give me a number to say what the
I'm
revenue
sorry.
is. I'm going to do it if you don't give me one, so you might be better off giving me one.
I'm grateful for that invitation. The problem is that our clients are obviously in a wildly different time zone, and we have literally not been able to take instructions on it. If your lordship would give me at least the indulgence of tonight, we will be able to get
absolutely fine. And
I will contact the court accordingly. Sorry, I did mean to mention it at 2, but I thought it was better to let my learned friend get on with it.
Thank you. No, well, thank you very much, both of you. But whilst you two are the mouthpieces, may I thank in particular junior counsel on both sides and also those sitting behind, because I'm acutely conscious of how much work goes on behind the scenes in order to allow the leaders to stand up and make the submissions. And I've noted throughout how much assistance junior counsel have given their leaders in this case, so thank you too. You won't be surprised to hear we're going to reserve our judgments. They will be sent out in the normal way in draft for typographical and other implicities, but obviously not to re-argue, please. May I just remind you of the new term, well, it's not that new now, the terms of the embargo that will appear on the draft. Now, really, again, I think this most commonly falls to the task of the juniors and the instructing solicitors behind, particularly in a case like this, which is full of confidential material. It's absolutely essential that the terms of the embargo are agreed with, that I'm sent a proper list of the people that are going to have access to any draft, and that there's no leakage, please. I hope anything else can be dealt with in writing, but if not, in an agreed order in due course, if not, we'll deal with any other supplementary applications in writing. So unless there's anything else that you need to draw to our attention, or which we need to deal with today, no? Well, thank you all very much.